Get you?
Maybe you can this afternoon. I don't know.
I'll maybe do that.
Thanks, Fred. Have a
See
good
ya.
day.
Yep. See y'all.
Thank you. Over here, yeah, I see it.
Okay.
What's it say?
Let me know as soon as possible. There's an event for ULI.
What is it? Oh,
Good morning.
Oh, I agree. This is when? August 26th?
Morning.
Oh, now I know.
these are the only two sheets you want us to print, right?
Yeah.
Say again.
These are the only two sheets that you asked us to print?
Yeah. Chinese coffee.
Chad, I'm sorry I took your seat. Hope you'll forgive me.
Out and then left it on like
Chad, that camera is right behind you. Let me just make sure.
No.
You mind?
Printed it out and left on the countertop and before. Sorry, I got it off. So did you go anywhere or just?
Guys, I went fishing on Friday.
Nice.
Saturday morning,
What's up?
so.
What's up? LA.
Ooh, that's,
For a wedding, man, I know. Long Beach, actually.
oh, that's real special.
Yeah.
How was the
Coast to
weather?
coast. It was actually not that great. It was a lot cooler than here.
Yeah.
I shouldn't say it wasn't great. It was actually nice. It's just in the mornings it would be very overcast. By midday it got really nice. And when you're talking about the difference in humidity, it was awesome. Like it was, it's just so much less humid over there. But it got cold at night. It definitely, it's definitely it wasn't. That's just that morning was a little weird. It's a wedding, so.
Weddings are weird.
Yeah. Probably exceptionally on the fun side. I thought it was too much fun.
How you doing?
Yeah, I'm alright. I've been watching the video.
It was a nice break, wasn't it?
Yeah, it was.
I actually took days off from work, so it's like a week vacation for me. It was awesome.
It's good.
I go to the conference for
Yeah. It's actually in St. Pete.
You're taking construction?
Yeah.
Working or?
I don't know.
Yeah, project?
Well, I did do one real estate.
I mean, it's interesting.
No, primarily.
But it's just ever know about forces.
Oh, for sure.
This is
Actually,
odd.
it is a.
I'm like, I don't know what to print those.
Right.
I'm gonna have to do it.
Exactly. I hear you.
Can
I like the instructor though.
yeah, he's very smart.
Yeah, smart.
The construction one?
Trying to
Yeah.
find.
Yeah.
Kind of comical a little
In
bit.
Chicago, I feel like I've heard that like every
Oh,
time he
100
says Chicago, he
times.
has to say he's from there.
Yeah.
He's very much about himself.
Very much think so.
Yes.
And then he says that he's in a different time zone for the time too.
Yeah. I think because we're in different times, like, we get it.
Alex grabbed these from me.
So we'll email you and we'll reply when we're done.
Right, that's what I get out of that.
You can watch it from the online. The first time we were like, oh, but then you can go on.
Secret envelope.
The winner is. Not bad.
forgive me, I'm gonna sit today, I hope that's okay with everybody. You can't hear me? Tell me, please. I'd like to start reviewing our quiz from last week. Just to tell you what I thought the answers ought to be. Once you review them against what you wrote, and again, I'm hopeful that the quiz will be of some value to you to see the type of questions we'll do in the future. How many levels of courts exist in both the Florida and the federal system? The answer is 3. Ignoring the precise court names, what are the generic names of the levels in each? They are the trial court, the intermediate appellate court, and the Supreme Court. And the description of the functions at each level. Trial court determines the facts through evidence, which can be witness testimony, exhibits, with or without a jury, decide what the facts are, and then secondly, applies the law to those facts. It's going to be one judge making that decision. Next level up is the intermediate appellate court. Its sole function is to decide, did the trial court correctly apply the law to the facts? There's no evidence, no testimony. The determination of the trial court of the facts is binding. It's not reviewed again. Simply attorney briefs and attorney oral argument. There'll be a panel of judges who will write an opinion. The opinion will contain a holding, and the holding will create precedent which other courts have to follow. Supreme Court's function is identical to the intermediate appellate court. It's limited in the cases it accepts. They usually involve interpretations of the Constitution or comparison of actions or statutes and laws to the Constitution, but its function is identical. Writes an opinion, creates precedent. No evidence, no testimony. Anybody have any questions on that? Okay. Second question, what is a fixture? What is a trade fixture? How do they differ? A fixture is an item of personal property that, when affixed to land or building, becomes real property. You keep straight in your head that word affixed. It helps for fixtures. A trade fixture is the same thing. But a trade fixture involves a tenant. And a couple of you mentioned tenants, a few did not. A trade fixture can only be affixed to property by a tenant for use in the tenant's trade or business. This is not residential. This is commercial only. That's why it's a trade fixture, the tenant's trade. Ordinarily, a fixture cannot be separated from land once it's been affixed. However, a trade fixture can be removed by a tenant at the end of a lease. An important factor that you might want to throw in there is intention. The intention of the parties when the property was affixed. Being affixed by the owner intends for it to become a part of the land. Affixed by a tenant, the tenant had no intention for it to become a part of the land. The tenant intended to take it with him when he left. So that's a trade fixture. Any questions? Okay. Chapter 4. Chapter 4 is called Estates in Land. It's got a lot of Old English history in it. none of which I think is really relevant today. So we're not going to focus on it, or on any of those terms coming out of the Old English history. Allodium, feudalism, they're interesting only from a historical perspective, but you'll never hear about them again in real estate practice. The first important concept to come out of the chapter is freehold estates versus non-freehold estates. And again, you're not responsible for understanding the distinction between the two because you'll never hear the term again. It's all about whether an estate and land has a certain definite duration or an indefinite duration. And remarkably, the result of this stuff is kind of bass backwards from what you would expect. A freehold estate has an indefinite duration, and an indefinite duration is actually better, a higher level, because it can last forever. A non-freehold estate has a certain term, like a lease, 3-year, 5-year, 10-year. The point is, it has a definite end, therefore it is a less good estate, and is therefore a non-freehold estate. But again, those terms are not important. The first real important concept in the chapter, though, is fee simple. Fee simple is ownership of land as you think it is. It's simply somebody owns it, totally, completely. It's the entire bundle of rights. The owner can do whatever he wants to with it. He or she, sell it, mortgage it, gift it, will it, devise it in a will. It's basically, until we distinguish it from a few of the other concepts, it's land ownership as you know it. The earlier stuff in the chapter was explaining how we got there in history, but again, I don't think it has any relevance today. You're going to hear this term expressed 3 different ways. Fee, somebody will say who owns the fee, or fee simple, who has fee simple title, or fee simple absolute. They all 3 mean the same thing. They're used interchangeably, and they're not really even used that often because this is simply land ownership as you understand it. You own the whole thing, you can do whatever you want to with it. So now we're going to distinguish that fee simple absolute ownership from certain lesser types of estates. And the first one the materials tee up, and this is the only important term I think out of these, is called the defeasible fee. In other words, it's fee simple absolute that can be undone, that can terminate on the happening of some future stated event. And we're going to talk through examples and stuff. But that's what we're saying, is you have fee simple, but some event that happens in the future ends your fee simple ownership. The materials talk about 2 different types. We're going to go through the examples, but you're not responsible for understanding the difference between fee simple determinable and fee simple subject to a condition subsequent, because you'll never hear those terms again. The only important concept here is a fee simple that can terminate based upon some condition in the future. And let me see if I can make that make some sense.
What's that called? Is there a term for that?
I'm sorry,
Is there a term for that?
is there a term for that?
Is there a term for that? Where your fee simple absolute can be terminated?
A defeasible fee.
Infeasible.
A defeasible fee simple, you can call it, a D-simple fee simple absolute, but the concept is defeasible. Defeasible meaning undo it. It can be undone. Now, let me give you an example that hopefully will make this make some sense. If you conveyed property to somebody and you put in the deed, so long as this property is used as a church, the owner continues to own it, possibly forever, so long as it's used as a church. When it isn't any longer used as a church, when the condition is violated, the estate becomes defeased, meaning it is no longer a fee simple absolute, and it's going to revert back to the prior owner.
There's an example in the book right about that. There's a case.
That was a good example. I'm going to give you a local factual one, but the one in the book was good about, I think it was for environmental, wasn't it, based on a violation of environmental condition. And I've got one that's similar for you, but the book tries to distinguish between these two types of defeasible fees. One where it automatically ends when an event happens, and one where it may end if an event happens. It's not really important, the distinction between the two, because as far as you're concerned, you want to be so sure that that condition is not violated and the ownership doesn't end. It really doesn't matter whether it may be ended or automatically ended. You've got a problem. Some of the buzzwords that will help you pick up on this, that you'll see when one of these things is created, are things like so long as, or but if. And the concept, as we talked about for a second, so long as this property is used as a church, works and happens a lot. And that exact example happens a lot, where people leave property in their will to a church, but they want it to continue to be used as a church. They don't want the church to sell it off to 7-Eleven and make commercial property out of it. What you need to understand, when it ends, when the fee simple then ends, when it becomes defeased, title reverts back to the prior owner, the person who gave the deed or gave the gift and who imposed the condition. Give you a local example that hopefully can make this make some sense. Birch State Park. Everybody know Birch State Park? Anybody know Birch State Park?
Where is it?
Birch State Park is a mile of beach in Fort Lauderdale, downtown Fort Lauderdale. Sunrise Boulevard, if you take Sunrise Boulevard all the way to the end, the first mile of beachfront property north of Sunrise Boulevard is a state park. It's named Birch State Park. It's named after a guy named Hugh Taylor Birch. Mr. Birch left his property to a college, left all of that property to a college. I think it was Hanover College, I've forgotten exactly the name. But the trustees of the college decided to deed it to the state of Florida. And in the deed, to create a park. And in the deed, they said, so long as the land remains in its natural state. So title is now owned by the state of Florida. But with this defeasible condition in there, so long as it remains in its natural state. And here's what the effect of this has been over the years. Birch State Park was grown over with Australian pines, 50, 60, 70, 80-foot big green pine trees that are deemed an invasive species, that are not natural to Florida. Somebody got the idea that, oh my God, if we don't get rid of all of these invasive trees, the land will not be in its natural state, and perhaps the whole park will revert back to the college, and the state of Florida will lose title to the state park. So they came in and cut out all of the Australian pines that had filled that entire park for maybe 100 years, and cut it back to simply palmetto scrub brush, sea grape trees, low elevation stuff. A lot of folks like me believe it used to be a really gorgeous, beautiful, green, tall tree, wonderful place. I grew up hanging out there. And 15 years or so ago, they came in and just cut down every tree and left it to be really palmetto scrub brush. And now, they've improved it with nice paths and nature trails and walks and all this good stuff. But the park is not at all what it used to be. Interestingly, it's not even now what it was when it was left to the state of Florida. When it was left to the state of Florida, it had these Australian pines. But the concern was, what if it's not in its natural state, which is interpreted to mean original native shrub?
Did you say that the pines were there for almost 100 years or something?
It's my understanding this goes back to the
So
early
would that be
1900s.
the natural state because it's been like that for 100 years and that's how it was handed over in the natural state?
I understand what you're saying, and I certainly agree with that. However, those who make these decisions didn't agree.
Okay.
And that it has not been tested in court. But the point is, that's the reason, that was the justification for coming in and cutting down all the trees was, oh my God, what if we lose this state park as a result of not maintaining it in its natural state? So this stuff does have some real application. You can imagine what that 1 mile of oceanfront property running all the way from the intercoastal to A1A would be worth if it reverted back to the college and the college could sell it to developers to put in condos. So it would, very, very valuable high-end piece of property that would conceivably have title pass under defeasance as a defeasible fee, reverting back to the folks who made the gift or made the conveyance but imposed the condition. So that's what a defeasible fee is about. So we've got fee simple, and now we've got ways that the fee simple can be taken away based upon the happening of a future event. The next lesser type of estate than fee simple is called a life estate. And life estates are very common in estate planning. And a life estate is an estate that is measured in its term by somebody's life. Meaning, the person who owns the life estate has the right to occupy, use, have possession of the property for a period of someone's life. Usually it's that same life tenant, but not necessarily. You could create a life estate in Andre, measured by Ryan's life. You could say, you are a life tenant, you have this property until Ryan dies. Now that's not usually how it happens. Usually the estate is granted to you for your life and says that you get to occupy the property for the remainder of your life. I don't want to, that's a bad word. Because at the end of the life estate, the property goes to a person called a remainder man. So when a life estate is created, it creates the right for someone to occupy the property for a lifetime, for a period of life, somebody's life, usually the life tenants. At the end of that term, upon the death of that life tenant, the property then passes to the remainder man.
Is that one word?
I'm sorry?
Is that one word, remainder man?
Remainder man, yes, remainder man is one word. Now, that remainder man may or may not be the person who created the life estate. Normally it is. Normally, I would deed property to Andre, and I would say, I hereby grant to you a life estate in the following property. If I say nothing further, that means it's measured by your life, and upon your death, the remainder brings it back to me, the person who set up the estate.
You said nothing else.
I'm sorry?
You said that if you say nothing else, so if you just say that first
Life
thing,
estate to Andre.
that's all you say?
If that's all you say. If that's all you say, it's measured by his life.
Then it goes back to
The person who created it,
automatically.
upon his death, the day he dies.
Okay.
As soon as your death certificate is filed in the public records, it's mine again. But understand, and this doesn't happen often, but I could say, I'm giving the property to Andre for his life. And at the end of his life, the remainder goes to Alex, if I wanted to. It would still be measured by your life, but it wouldn't come back to me. It would go to Alex. And the importance of this stuff is that these different estates can be transferred. You then, under my factual situation I gave you a minute ago, could convey to Chad your remainder interest. You could say, hey, when he dies, Chad, it's yours. You can't take away his life estate. He still has the right to live there for his life. But you can determine that the remainder is going to go to somebody else. In addition, as a life tenant, you could transfer to Ryan the right to live there. But it's still measured by your life. You can't change, okay, let's put the life estate in Ryan and let's measure it by his life. When I set that up, I said there's a life estate to be measured by your life. Now, I know I'm making this confusing, but I just want you to understand there are these different variables out there where a life estate is an important concept, and I'll give you an example in a minute of why we use it. But to understand that these different estates, like we talked about, mineral rights can be transferred. We talked about air rights can be transferred. Well, now we're talking about estates, possessory rights can be transferred. Okay?
So if he transferred his life estate to me, but it's still measured by his life.
Exactly.
The only way for him to evict me is he'd have to take his own life.
I'm sorry?
So the only way for him to evict me from the land, he would have to die, right?
Yes, that would end your estate.
Right.
That would end your estate. And the remainder man doesn't get it until he dies.
Sure. Okay.
But then you're out.
Right. Then I'm out.
So
Yeah.
I kick you out after he dies, and I say,
Yeah. Or you shoot him
to
to get the land.
It just seems ass
Right.
complicated.
Okay.
Now let me tell you how these things get. This all sounds like a bunch of silly mumbo. Yes, sir.
No.
So, I mean, the person, for instance, me, who the life estate is in, I mean, what can you do with the property? Can you
Live there.
Can you
Rent it. Rent it out. Collect the rents.
You have full rights to the property.
Can you mortgage it? Get.
We're going to talk about that in a second.
Okay.
We're going to talk about that in a second.
You have to guarantee you're going to stay alive for the life of him.
That's the problem for a lender, of course, and we'll discuss that in a second. But let me give an example so we can make this make sense. This happens all the time in estate planning between parents and kids.
Mhm.
Parents want to reserve the right to live in the property for the rest of their lives, but then they want it to automatically pass to their kids. If they set up a life estate, it doesn't have to go through their probate. It happens instantly the moment they die. Instantly title belongs to their kids. And their kids can't change that. And their kids can't, during the parent's lifetime, go out and screw it up. They can't sell it, mortgage it, sell it out from under the parents, because the parents have a life estate and are entitled to live there for life. And the further beauty of this is, we're going to talk later about homestead exemption for real estate taxes, stuff like that. Some of you probably have some familiarity with that. Life estates work, and you can still get a homestead exemption for real estate taxes that we'll discuss more fully later, even if you have a life tenant in there. So life estates happen an awful lot in estate planning situations between parents and children. Frankly, it's rare for them to happen in any other situation. But what you need to understand is the concept that if you're dealing with somebody who's occupying a piece of property and you think they own it, it's conceivable that they only own a life estate. Okay, now,
Quick question. When the life estate goes to the children in that example, does it then become a fee simple ownership?
absolutely.
Okay.
Fee simple, absolute. Yes. It's a fee, the remainder, once the life estate is gone, is a fee simple absolute in the children.
When it's made into a life estate, can the parents sell the property? And
Well, okay, let's talk about that. The life estate theoretically is saleable
okay.
or mortgageable. But think about that. How much would you pay me for his life estate that might only last a week? Might last 50 years. You might be able to collect the rent for 50 years.
Yeah.
That'd be cool.
Mm-hmm.
But it could last a week, in which case, how much are you willing to pay for that?
Yeah, no, I see what you're saying.
How much is a lender willing to loan on the security of a life estate
Yeah.
that could end next week? So it's important to understand that the life estate is saleable and it is mortgageable, but it's just not very marketable. There's no market for that. But here is a market for it. It's leasable. If you have a life estate, you can rent out the property and collect the rents for as long as you're alive. That makes sense in the sense of, I wouldn't mind leasing from you your property and your life estate, because if I'm only going to pay your rent monthly, if you die next month, well, it's over, I'm not going to pay you next month's rent. In other words, I'm not going to pay $10,000 that turns out to be worth only a week's term. But if you lease it and pay for it monthly, then when the estate ends, you quit paying the rent. But you have an asset.
Does the lease hold even if the property goes to the remainder?
I'm sorry, say again?
Does the lease hold even if the property goes to the remainder man?
The lease ends because you only got a lease from the
So
life
it
tenant.
ends whenever.
It ends
Oh,
because
okay.
if you only got your, if you
have
only
a
got
fire.
your lease from the life tenant,
Right.
if you went to the remainder man
And asked if he
and
could-
said,
Right.
both of you guys, I want you to sign a 10-year lease to me,
Okay.
then you don't care. It's a question of who you're paying the rent to. But other than that, I get to be here for 10 years.
Great.
Now, it's important to understand, as between the life tenant and the remainder man, there are different rights and obligations as they relate to the property over time. The life tenant is entitled to collect the rents, but he also has to maintain the property. He has to pay the taxes on the property. If there's a mortgage on the property, he has to pay the interest on the mortgage.
Not the mortgage itself.
Principal payments are paid by the remainder man.
Even while he's living there.
even while he's living there. If any principal payments are due,
Yeah,
you know.
yeah.
But the concept is, if there's a mortgage on there and it encumbers your remainder interest, then it's in your best interest to be paying down the balance on that mortgage.
Of course.
Okay? But for him, he ought to be paying the interest on it because he's entitled to collect the rents.
Mhm.
People get in disputes over this stuff, of who should be paying what, who should be collecting what. Life tenants and remaindermen occasionally butt heads, and the law is pretty clear on this, but people don't really understand it. Another occasion where these arise, and again, we're going to talk about homestead in just a minute, but to understand a situation where this really comes into play. We have in our Constitution a provision that says that if property is homestead, this is getting ahead of ourselves, but there's a situation where homestead property passes by operation of law to a spouse, to a surviving spouse, for life. So we create in our Florida law a life estate in a surviving spouse of a homestead with a remainder in the children. So this can come up. If somebody dies with or without a will, it doesn't matter. If it's homestead, it's passing in accordance with law. Our Constitution says that that property, homestead property, upon the death of the owner, will create a life estate in the wife and a remainder in the children. So it comes about separately from estate planning situations. I mean, it comes about in a case of death, like we're talking about, but estate planning is something that people do in advance of death, where they're setting this estate up with their kids. But a life estate can be set up upon the owner's death by operation of law if in fact it's homestead.
One quick question.
Yeah, sure.
Let's say if the life tenant stops paying the real estate taxes or stops keeping the property, in the condition of, what happens then? Does the remainder man have to come in and can he take the property because he stops paying taxes on it, or?
He doesn't get to take the property, but he gets to sue the life tenant to force him to do so.
Okay.
And in fact, take the rents if necessary in order to cover those costs.
Okay. Okay.
Hand it up. There's one other important concept going on here as between the life tenant, and this is close to what you're talking about, Alec. The life tenant may not waste the property to the detriment of the remainder man. We talked about you have to repair the property. If there's a building on the property, the life tenant can't tear the building down because he's taken the building away from the remainder. You can't destroy the property. You can't start digging holes and mining the property. The point is, the life tenant is entitled to use it during the life tenant's life, but he may not waste the property such that he screws up the remainder for the remainder man, so that when the remainder man gets it back, he's getting it in a lesser state, in a less valuable state than it was when the life estate was created.
He's allowed to improve the property.
Absolutely, if he wants to.
If he wants to.
If he wants to.
At
If
his
he's
cost.
willing to spend his money to build another building that he may only get to keep for a week.
At his cost, though.
Exactly.
Okay,
Yeah.
that makes sense.
That concept is called waste, and you do need to be familiar with that. The concept that a life tenant cannot waste the property to the detriment of the remainder man. Okay. There are two ways to create a life estate. If I'm the owner and I want to give Andre a life estate, I can simply deed a life estate to him. And as we talked about, and I've kept the remainder. What happens more often in the parent-children situation is the parents will convey the property to the children and retain a life estate. And that's how these are most often created. Rarely, usually title is held by the parents. And it's the parents who want to retain the life estate and create the life estate in favor of themselves. So they convey the property to their children and retain a life estate. Okay? That's how they usually come about. But it is possible to convey a life estate to somebody. Okay. There's a concept discussed next that I just want to go ahead and dismiss because it relates to some of this estate planning stuff with widows and widows' rights and properties, is the concept of dower. The materials talk about dower, D-O-W-E-R. Don't learn about dower. We do not have dower in Florida. Florida has abolished dower. We had it up through maybe the 1960s.
Oh, wow, okay.
It was a strange concept. And, you know, candidly, it's so complicated, it's not worth going into. It was all about the concept that during a marriage, the wife owned a dower right in all property owned by her husband, which meant that every time a husband sold a piece of property, the wife had to sign a deed, even if she wasn't the owner. Because if she didn't, she owned a 1/3 interest in that piece of property. We've abolished that. We do have provisions, as we talked about a moment ago, and we'll talk about some more in a minute, where upon the death of a husband, the widow can have some rights in a property under homestead, which we'll talk about in a second. But the dower concept, which is the Old English common law concept of the wife's ownership interest in the husband's property, is gone. So forget dower. Now, I want to talk to you for a few minutes about an unrelated subject, unrelated to the materials, related only in a little way that I'm going to tie it together for you, but there is no other proper place to tee up the concept of homestead in Florida. It's of course not in your book. This is something very unique to Florida. Florida has a very huge area of the law, of real estate law, called homestead. Homestead has 3 different meanings. Judges call homestead the legal chameleon because it continues to change. And we have provisions in our Florida Constitution about homestead, and we have provisions in our Florida statutes about homestead. And we have tons of case law interpreting those statutes and those provisions as to what do they mean. And still nobody knows for sure what they mean, and they're still constantly being litigated. Homestead means 3 different things. And the first one is the simplest, easiest. Homestead, well, let me back up and say what homestead is. A homestead is a piece of property owned by the head of a family who maintains his family living on that homestead property. This is the family home. And Florida treats that very specially in 3 ways. There are a lot of tests about head of the household and who's providing support and are the kids dependent on the parents and who's living there. And you get into all this factual bunk of is or isn't a homestead. But if it is a homestead, we've got these three concepts. The first one is an exemption from real estate taxes. Not total, but partial. If a piece of property is homestead, owned by the head of a family, supporting his family there, his kids live there, this is the home, then the property receives a $50,000 exemption from real estate taxes. Now what that means is, and we're going to talk much more about taxes later, but if you're not familiar with real estate taxes, a property has a certain assessed value as determined by the property assessor, property appraiser. And if property is assessed by the property appraiser at $100,000, then the way you pay taxes is the different governmental bodies, county, city, fire department, hospital, each of them levies what's called a millage. That's a percentage. And all those different percentages of taxes are then applied against your $100,000 assessed value. And that's how you come up with what your real estate taxes are every year. So you have a piece of property, this homestead. The property appraiser says it's worth $100,000. All the different governmental bodies add up their levages and they end up with maybe 2.5%. So that the taxes on that $100,000 piece of property per year are going to be $2,500. Now, if it's a homestead, $50,000 is exempt from taxation. So, in that exact same situation, you're only going to pay taxes based on $50,000 of assessed value. In which case, your taxes are going to be $1,250 rather than $2,500. They're going to be 2.5% times the $50,000. All right, that's what an awful lot of people mean when they say homestead. That's all a lot of people know when they say homestead. It is it's the layman's interpretation of homestead, and it's important. It's valid. You can have one homestead only. Everybody just gets one. And in other words, you can't own 7 pieces of property and say, yeah, I live here this week, I live here that week. You get one. Every year you have to re-demonstrate to the property appraiser, yeah, I still live there, that's my homestead, and therefore I get that deduction on my real estate tax every year.
Is there anything special you have to do to qualify a property as your homestead? So let's say I bought a house last year and didn't do anything extra, just sign on the dotted line and have a house.
Okay.
Is there anything else I have to do to qualify that as my homestead?
Yes, you have to file with the property appraiser.
Okay.
By January 1 of the next year. You have to prove to the property appraiser that you live there.
Yeah.
Not just that you own it, that you live there. They want paid utility bills. They want to see a driver's license with that address.
Yep.
They have a whole bunch of different tests that they make you prove to them, yeah, this is my home. And for this test, for the homestead test, for the homestead real estate tax exemption test, you don't have to have a spouse living there with you. And you don't have to have kids living there with you. You own it. It's your residence. Everybody gets one homestead. You get that tax exemption.
Isn't it that if you're like by yourself, single, you get like a $25,000 exemption or something?
Say again, I'm sorry?
If it's just yourself that had the household, it's not the whole family, don't you really get like a $25,000?
No. There's something real confusing about the $25,000 exemption. Let me explain to you. In this homestead exemption, in its original provision, said that the first $25,000 of taxation is exempt. Okay. Then we passed a constitutional amendment 7, 8 years ago that says there's an additional $25,000 homestead exemption, but it only begins at $50,000 and goes up to $75,000. So, under our factual example of a $100,000 house assessed for $100,000, you're going to get both 25 exemptions. You get a 50 exemption. But what it really means is, your first 25 was exempt, your second 25 was taxed, your third 25 is exempt, and your fourth 25 is taxed. The distinction is important if you have a $45,000 house. If you have a $45,000 house, the first 25 is exempt. You don't get the benefit of that second exemption because you didn't make it over 50. This is just a strange way that the constitutional amendment was written that says that the third $25,000 of assessed value is exempt. And to tweak it and make it a little bit more complicated, it's exempt from every type of taxes except school taxes. So you're exempt from city police and fire and county and sheriff, all that stuff, but school taxes are not exempt. So when you see a tax bill, you see the different assessed value for the different purposes.
The whole homestead, you have to pay the school tax on the whole property value.
Yes, there is, no, forgive me. The first 25,000 is exempt from school.
Okay, the second.
It's that second 25, which is really the third 25.
Oh, yeah, okay.
Is not exempt from school. None of this is really important except to understand an understanding of homestead. That's the first thing that homestead means in Florida. An exemption, a partial exemption from real estate taxes. Yes, sir.
What if you purchased your home like 2 or 3 years and you missed the first 2 homestead? Can you apply for the 2 years that you didn't get?
No, you missed it.
You missed it.
You can only apply prospectively going forward.
Okay.
You're still entitled to it going forward, but you blew it. So there's a filing deadline. It's March 1 of each year for that year. So in Ryan's example, you bought a house last summer. You've got until March 1 of the following year to apply for the next year's taxes. See, our taxes, again, we'll get into this more. Our taxes are assessed at the end of the year for the preceding year. So, for example, for right now, we will have taxes assessed for the year 2015. The bill won't come out until November, but it covers 10 months behind you, 2 months in front of you, because it's the tax year for 2015. And if you bought a piece of property in 2014 that you wanted to have homestead exemption on in 2015, you had to file by March 1 of 2015, or you've missed it for 2015. But you could still file again in 2016 to get it for 2016 and thereafter. But you just can't go back. If you don't file by March 1 of any year, you lose it. So, yes, ma'am.
How long do you have to live in the homestead for it to be considered a homestead?
How long do you have to live?
Yes.
Just present. In other words, by the end of the year. By January 1. That's the test. Did you live there on January 1 of this year? If you did live there on January 1 of this year, you're entitled to homestead exemption for this year. Even if you move out in February. Of course, if you move out in February, you'll lose the exemption for the next year. If you move out in February and you've sold the house, well, you really don't care. Somebody else's problem. They're paying the
I
tax.
don't really understand what is the idea of the homestead? So could my parents call their home their homestead if they live there all year round?
Sure, absolutely.
It's just a tax break for families in Florida. It's been around for a while.
Yeah.
If my parents live in a house wherever and they have a homestead on it, it's just a tax break. It's just a way to save money on taxes.
There's another whole concept that's related to that I'm not going to get into now. That's something called Save Our Homes, and that's a different factor that relates to the amount which your taxes can go up. But we're not going to talk about that now because that's not homestead. Yes, sir.
Can you transfer your homestead? Say you sell your house and you buy one quickly afterwards. Can you transfer your homestead into that new property?
No.
Okay.
No.
I think that's you need to
You
wait
can
the year.
transfer this other Save Our Homes thing I talked
Okay,
about
yeah,
for a minute, but
yeah.
you cannot transfer.
You have to wait.
You have to wait and file next year.
Reapply.
Yeah. If the house that you bought, if the people you bought it from filed for homestead for that year, well, you'll get the benefit of it for that year. You get the benefit of their homestead exemption.
Oh, okay.
If If homestead exemption for whomever was in place on January 1, when the bill comes out in November of that year, it's going to be discounted.
Whatever
No matter who the owner is anymore.
Okay.
Okay. But likewise, it's going to go away
If you don't really.
if you sold it.
Yeah.
The new owner will then have to file for his own homestead exemption. Okay.
So technically, you could just have, if they have a homestead on it and you apply in time, you could not use the benefit.
You're not using their homestead. It's on the property for the year period. Okay. Number 2 meaning of homestead. The homestead in Florida is exempt from creditors. This is huge. This means if somebody sues you and gets a judgment against you for $1 million, they can attach and have a forced sale of all of your other property except your homestead. And if you happen to own $1 million house and somebody gets $1 million judgment against you, well, that's tough for the judgment creditor. Homestead is exempt.
That includes declaring bankruptcy, right?
I'm sorry?
Declaring bankruptcy, it also protects it from.
Exactly. In bankruptcy, you can keep your homestead and come through bankruptcy.
Right.
That exemption, this gets more complicated, and just follow me through here for a second. But that exemption even lives on in your estate proceeding when you're dead. Your other creditors, after your death, creditors have claims against your estate. They can file their claims and they can be paid out of your estate. But they can't be paid out of the proceeds of that homestead. If that homestead is sold for $1 million in the estate, that $1 million is going to pass to the beneficiaries. Notwithstanding a creditor's claim out there for $1 million, because a creditor can't touch the homestead or the proceeds of the homestead. So that's a real important concept that most people aren't aware of, but it's huge in Florida in terms of, a lot of people consider their homestead to be their greatest retirement savings thing. Pay off your mortgage. Because you can own the property free and clear, and it's still exempt from creditors. It's immune to claims from creditors. What you find is, in fact, you'll occasionally find somebody being sued, and they will take their money out of the bank and pay off their mortgage on their homestead so that they have a valuable free and clear house that the creditor can't attach. But if they left the money in the bank, the creditor could have attached it in the bank account.
My father did that once.
I'm sorry?
My father did that once.
Okay.
He was being sued in a real estate deal, and he didn't know, what was going to happen, so he went ahead and paid the mortgage off with the homestead, and the lawsuit got dropped, but it was just one of those protections.
It's exempt, and it works, and that's been tested in the bankruptcy courts, and just plain old, it's in the Florida Constitution. And creditors, banks try to undo this every year. They hate it. But, they can't.
Is there a timeline, let's say when someone dies and the homestead's still on the property, to sell the property so the creditors can go after it? Let's say, for instance, if my parents die and the homestead's still on the property, but when it expires a year after, because unless I file for it, if I don't file for that homestead, can the creditors go after the property?
You need to understand that the filing that we talked about for real estate tax purposes has no bearing here whatsoever.
Okay.
It's that the annual filing for the exemption from real estate taxes is strictly as to real estate taxes.
Okay.
A homestead, once a homestead is a homestead, it's a homestead forever.
Okay.
You don't file with anybody. You don't have to file it. Now, often the fact that you had homestead exemption for real estate taxes is evidence that it was your homestead, but there's no filing to make it be a homestead. So the point is, what will happen is a creditor, under our situation, a creditor will try to get the court to attach that piece of property for his $1 million judgment. And the owner will come in and claim, no, it's homestead, it's exempt. And the court will determine whether or not it was a homestead. And if it is a homestead, then it's exempt. But there's no filing where you go sign something with somebody and say, that's my house, it's exempt. It either is or it isn't, and that's a legal test that a judge will decide.
Okay.
All right. Now, there's a third thing that homestead means, and that's why we're bringing it up particularly in this connection. If you individually are the owner of a homestead, you cannot will your property if you're survived by a spouse or by minor children. Now, here's what all this is about. This is a protection for the family that Florida has built into its Constitution. The concept is the head of the household owns the house, raises family there, family lives there. He can't, in his will, leave it to his girlfriend. The state has determined, no, the homestead is going to pass as a legal life estate. The type of life estates that we just talked about. One of them is, we talked about there are ways to create them. I can convey a life estate to you. I can convey the property to you and retain a life estate. The other way that life estates are created are a legal life estate. This situation we talked about is a legal life estate because here's what happens. Our Constitution says the homestead is not subject to devise, which means it can't be willed, if the deceased homestead owner is survived by a spouse or by minor children. And if so, the property passes as a life estate to the spouse with the remainder in the children. So those concepts we talked about before of a life estate and a remainder can be imposed by law upon the death of the owner if the property is homestead. And then the wife and the children are in exactly that same situation we talked about before. Of the wife gets to live there, the wife gets to rent it out, can't waste the property, the children own it upon the wife's death, upon their mother's death. All of those concepts that affect the rights between a life tenant and a remainderman come into play in this situation. Set up by operation of law, though not set up by something the parties did. Okay? I know this is complicated stuff, but it's very relevant in Florida. And it's relevant only in Florida because these are unique creatures of the Florida Constitution and Florida statutes. There are provisions kind of like this in the law of all other states, different types of ways to protect. This is all about the concept of the legislature, Big Brother, wanting to look out to protect the family, to protect the surviving family, protect the family in its home period during the owner's life against creditors, and protect the home after the owner dies for the benefit of the family having a place to live, the spouse and kids. Okay, that's homestead in Florida. There is nothing else in this chapter that I want you to learn or pay attention to, or that you're responsible for. I want to tell you about this one concept at the end here, but we're not going there. This is an entire class in law school, and it's called future interests. And all future interests are all about is the rights, is the rights of parties to an interest in the property sometime in the future. Just like it says, future interest. An example of this is a remainder, is a future interest. A remainder, that we talked about, the remainder man, the remainder. That is an interest in property that will arise in the future. But there are dozens of other different types of this that were created under Old English common law. They still exist theoretically, but you'll never see one, you'll never use one, nobody talks about them. It just, one of those things that's out there, but it'll never happen. So I don't want you to be wasting any time learning about something you'll never see again. Okay. That's it for chapter 4. Anybody have any questions? Comments? Okay, let's go on to chapter 5. Chapter 5 has an awful lot of meat in it, a lot of good relevant stuff that you're going to see and you're going to use and you're going to deal with on a regular basis. Things we've done previously are interesting, if you want to use the term, maybe not interesting, esoteric, and concepts. But the stuff here in chapter 5 is real hands-on matters that affect ownership of property. I'd like you to read, and I'd like you to talk about, I'd like to talk about and focus on for only 2 seconds the first paragraph of this chapter, which I think is excellent. It's on page 94. And it kind of tries to put into perspective what we're going to deal with here in this chapter, which is the concept of co-ownership. But even this concept of co-ownership is kind of a misnomer, because there are so many different concepts going on here in this chapter. But to try to bring them into focus, this first paragraph says, it kind of gives you perspective. It says that we've learned already that some of the different ways that ownership of land can be divided. We learned that ownership of land can be divided as between the surface owner and the subsurface owner of the minerals, or the air rights owner. So we're dividing ownership of land there based upon something physical, the surface, the subsurface, over the surface. That's one way that ownership is divided. In the prior chapter, we talked about a way that ownership can be divided in property based on time. We've said that somebody can have the life estate and have virtually full ownership rights now at this period of time, and somebody else can have ownership rights in the future, the remainder of it. So there we've divided ownership of land over time. We're now going to divide ownership of land among more than one person. And we're going to talk about how 2, 3, 7, 10, 100 people can all own a piece of land at the same time. Simultaneously, all right now. Co-ownership simply means 2 or more people who have what we call undivided interests in the same property at the same time. Now, what that simply means is you and I together own a piece of property right now, together. We jointly own the piece of property. That was a bad term. We together own a piece of property. Co-ownership means that we each have an undivided interest. We each have a 50% interest. If there are 2 of us, if there are 4 of us, we each have a 25% interest in that piece of property right now at the same time. I want to distinguish that from, and a lot of people get confused over this concept of What if this whole board here was one farm? And I own the west half, and you own the east half. That's not co-ownership. That's plain old fee simple of that piece of property and me. Fee simple and you of this piece of property. We happen to be neighbors. But we're not co-owners. We don't co-own anything. Co-ownership is you and I together own the whole thing at one time. We each own an undivided 50% interest. We haven't divided the ownership into you get that half and I get this half. That's divided ownership, and that's not co-ownership at all. We're talking about undivided interest in an entire piece of property owned by more than one person at the same time. And that's co-ownership. Now, what we're going to talk about is if we are owners at the same time, if we are co-owners, we're going to talk about all the rights and obligations and duties as between the two of us and what this means to be co-owners at the same time. And the first type of co-ownership we're going to talk about, the book discusses as joint tenancy. I'd like you right out of the box to know that you don't ever want to use the term alone joint tenancy.
Alone?
Alone. You always want to say in Florida, joint tenancy with right of survivorship. You're going to see this abbreviated everywhere, JTWROS, joint tenancy with right of survivorship. What this joint tenancy means, as the book defines it, and as we call it, joint tenancy with right of survivorship, simply means that upon the death of one of us, the other one owns the whole thing automatically. Survivorship. Survivor takes all. You'll see why in a moment it's important that we say joint tenants with right of survivorship. Florida has certain statutes that make it important that you say that, because if you don't say it, it's not clear what you meant, and Florida will interpret it differently. Other places around the country, the term joint tenancy alone means with right of survivorship. In Florida, you got to say it clearly. If it's the intent is upon the death of one, the other one owns the whole thing. Now, joint tenants, used in this sense, joint tenants with right of survivorship, each owner has an equal right of possession to the entire property. And that's that concept of the undivided interest we talked about. And disputes can arise over, and we'll talk about later, what if they do? How do we interpret the right that we both own the same thing at the same time, all together undivided? That can lead to all kinds of controversy and litigation, and we'll talk about what happens if that happens. But the concept, the legal concept is you both own the whole thing all together at the same time, 100%. And you each are entitled to occupancy of 100% of the property, but you each really own a 50% interest. Now that 50% interest becomes important because you're probably, if you own this property together, I'm going to assume for the purpose of these discussions that we're talking about commercial property that has rental income. And of course you're going to divide the rents 50-50 between the two of you.
Property taxes are split halfway too, or
Everything.
everything's split.
Income and expenses are both equal.
Let's say if one person does not pay the property taxes in joint tenancy, what happens then?
You end up in litigation soon.
Okay.
And I'll explain that at the back end.
Okay.
We're going to talk about each of these concepts and then we're gonna talk about what happens if somebody doesn't pay their share.
Okay.
Now, the materials talk now about under Old English common law, there were 4 unities necessary in order to create a joint tenancy. Forget that. We have a Florida statute that abolished the 4 unities. So the point being that in order to create a joint tenancy in Florida, you don't need to meet that Old English common law test of the 4 unities, which were just a bunch of bunk. You had to get it at the same time, it had to be equal, it had to be in the same document. It was just a bunch of silly tests. The point is Florida's done away with them, so that we can create a joint tenancy with right of survivorship in Florida without worrying about that concept. Now, let me go ahead and shift to tenants in common, and then I'll tell you about the other Florida statute that becomes relevant. The other type of co-tenancy, we call this, or co-ownership, co-tenancy, co-ownership between more than one individual, between 2 or more individuals, is called tenancy in common. Tenancy in common. Tenancy in common is simply co-ownership again with no right of survivorship. Upon the death of one of the co-tenants, his interest passes either under his will or by operational law, or however his other property passes. The point is, it does not automatically pass to the co-owner. Tenancy in common is the most common type of co-ownership. If you and I together are going to buy a parcel of commercial property and own it together, it's not likely that I'm going to want my interest upon my death to pass to you. I'm going to want it to pass to my family, just like you're going to want your interest to pass to your family. Whereas if family members own a piece of property together, often they do intend for their interest to pass, particularly between spouses, or often between siblings. They would say, I would intend upon my death that my interest pass to my siblings or to my spouse. Now, tenancy in common is simply co-ownership without survivorship, and frankly, joint tenants or right of survivorship is co-ownership with survivorship. There's really only that difference between the two, whether there is or isn't survivorship. All of the concepts of you're owning it at the same time, you're owning an undivided interest in common, are equally applicable to both tenancy in common and joint tenants or right of survivorship. Let me tell you why it's so important in Florida that you say joint tenants with right of survivorship. And we go on further and say even and not as tenants in common. And the materials allude to this, that the law is slowly swinging in this direction in most states. Florida has a statute that says, if you don't say otherwise, you own as tenants in common. There is a presumption in Florida that co-ownership of property is tenancy in common, unless you very clearly express your intent to the contrary. And the way that you clearly express your intent to the contrary is you say, with right of survivorship. Lawyers wanting to wear belt and suspenders and be double careful when they create the type of joint tenancy that is intended to have survivorship between 2 parties. They will say, title is conveyed to A and B as joint tenants with the right of survivorship and not as tenants in common. to make it doubly abundantly clear that they mean with the right of survivorship. Because this is important. If it's a $10 million piece of property, we're talking about is $5 million of that belonging to the spouse of the deceased, to the family of the deceased party, or is it belonging to his partner? It can be big. Now, we're going to,
Question.
yes, I'm sorry, sure. Go ahead.
The language has to be in the deed, correct?
That's where you put it.
What, okay.
Exactly, yeah,
The
excuse
deed
me.
has to say that.
That's where this language goes. Understand for a minute, though, and I'm going to talk about this with you in a second. As to real estate, yeah, it goes in the deed without question. These concepts that we're going to talk about here, and we've got a couple more of them like this, realize that they also apply to personal property. They also apply to stock certificates and car titles and bank accounts and brokerage accounts. When you set up a joint bank account with somebody, a joint, it's such a bad word. When you set up a bank account in two names, do you or don't you intend for there to be survivorship of those funds between the parties when one dies? That's when you say so, is when you set up the account. When you buy a stock certificate, you'll see on the stock certificate, it may just say A and B. It may just say Bill and Susie. If it says Bill and Susie and nothing else in Florida, what does that mean? Tenants in common, right? Because we didn't say anything else. But if you wanted to write a survivorship between Bill and Susie, you had to say as joint tenants with right of survivorship. And even better if you say and not as tenants in common. You're going to see this on stock certificates. They say there'll be two parties' names and it'll say right after it, JTWROS. Car titles, yes.
Yes, so I mean, if you have like a stock certificate of Bill and Susie, and Susie passes away, you're saying that it doesn't automatically go to Bill?
If they owned as joint tenants or right of survivorship, yeah. If they owned as tenants in common, no.
Who does it go to?
I'm sorry?
If they own it as tenants in common, who does it go to?
If they own it as tenants in common,
Yeah.
I'm sorry, what is your question?
Who does it go to if,
It goes to whoever they left it to in their will. If you die owning property that you owned as a tenant in common, okay, it passes under your estate. It passes pursuant to your will if you had a will. And if you didn't have a will, it passes by operation of law, but not necessarily to that other person. If you owned stock with your brother, a stock certificate with your brother, between two brothers, if the stock certificate says joint tenants with right of survivorship, then it's going to pass to the other brother upon the death of either one, right? That's clear. Okay. If it says nothing, or if it says tenants in common, when one of the brothers dies, it's going to pass however the rest of his estate passes. He may have a will that says, I leave everything to my child, not to my brother. He may not have a will, in which case our statutes say it passes equally to his wife and his children, if he didn't have a will. But in neither of those cases did it pass to his brother. It would only pass to his brother if it had said joint tenants to the right of survivorship as to that brother. Do you follow me? Okay, all right. Now, there is one additional type of estate that we're going to talk about, and I want to tee this up now for only 2 seconds, and then we're going to come back to it. There is a third type of co-tenancy or co-ownership that we're going to talk about, called tenancy by the entirety. And that's as between a husband and wife. And we're going to come back to that one in a minute, and here's why. As Alex asked the question before, and there are 100 different ways this can come up. What if co-owners of a piece of property have a problem between them? What if either one is possessing the whole property and keeping the other one out? What if either one is taking all the rents and not sharing? What if one is paying the expenses and the other is not? What if just plain old, I'm sick and tired of owning this piece of property with you and putting up with your petty crap. I don't want to own it with you anymore. For any and all of those reasons, any co-tenant, any person who is a co-owner of property has the right by law to have that ownership partitioned. This is an important buzzword you need to learn. Partition. Just like a wall between rooms. Partition. Partition is a legal action to have co-ownership terminated. And it can happen 3 different ways. Let me back up. It can happen voluntarily or involuntarily. And whichever of those ways it happens, voluntarily or involuntarily, it can then happen 3 different ways. Voluntarily is, we both agree we're tired of being co-owners. Let's split it up. Let's partition. Okay? Involuntarily is, one party wants out and applies to a court to say, Your Honor, I co-own this thing together with him. Partition it for me. Now, to make that make hopefully a little more sense, if together as tenants in common or as joint tenants with right of survivorship, it really doesn't make any difference for the concept that we're talking about. If together we own the farm here, not one of us owns the east half and one of us owns the west half, but together as co-tenants, we each own a 50% undivided interest in the entire farm, and we want to split it up. We want to end our co-ownership. Split it up is a bad term. We want to end our co-ownership. There are 3 different things that we can do. We can physically partition the property. If it were vacant land in a farm, that kind of makes sense. I'll take the west half, you take the east half. Let's physically split the property and partition our ownership by a physical division of the piece of property. But that doesn't work real well when there's a house right in the middle. So physical partition often doesn't make sense as between the parties. You can't really physically partition the house, split it in half. And it also, if you brought this action before a judge, it doesn't really make sense for the judge to do that either and say, let's split the baby in half because there's a house in the middle, it just doesn't work. So the second way to partition property is to sell it and split the proceeds. We can do this voluntarily, or a judge can order us to do this. And that would be simply the judge says, and the court holds an auction and sells the property and splits the money. The third way, and this is what usually happens, is one person buys out the other. That ends the co-ownership. The person getting out sells his interest to the person staying in. We've partitioned it all right. There's no longer co-ownership. One person owns it now. The one who wanted out is out. Likewise, that can happen voluntarily if the parties can agree upon terms. Usually, a court is not gonna order that, but it could. Now, let me tell you what usually happens in a court proceeding. The judge first makes a determination, there's no way I can physically split this thing. Maybe only one road coming in on one part of it, there may be scattered buildings, there's no way we can chop this thing into pieces and be fair to both parties. So you always make that first determination first, can it be physically partitioned? If it can't, the judge is going to order the property be sold at an auction on the steps of the courthouse, as we talk about. They don't really happen like that anymore, they now happen on the internet. But the concept is, let's have an auction at the courthouse and let's let people bid, and somebody buys the whole thing, and then you split the money. Now, what kind of sales price do you think property brings when it's sold on the steps of the courthouse? 10% of its value? 20% of its value? Not much. So once the judge has ordered that he's going to take our $100,000 piece of property that we can't agree on how to split it up, and he's going to sell it on the steps of the courthouse for $20,000, and we're each only going to get $10,000 out of this $100,000 piece of property because we can't get along and can't agree what to do, probably one of us is going to agree to buy out the other, because you're stupid not to. And that's what usually happens. Usually the parties come around to, yeah, gee, it probably makes more sense if we simply one of us buys out the other. Now, you may not have another situation, you may not have $50,000, but you can mortgage it, you can take paper, you know, there are ways that you can do this, as opposed to having the property be sold in a forced court auction for $20,000 and you get $10,000 each for your $100,000 piece of property. But those things are what happen when something goes wrong in the relationship between the two parties. Somebody's not paying their share, somebody's collecting all the rents and not giving it to the other side, somebody just plain hates the other guy and says, I wouldn't own this jointly with you on a bet, and I want out. And by law, you are entitled to be out if you jointly own a piece of property with somebody. Now realize, you could also, of course, have sold your 50% interest. But there's no market for that. Just like we talked about, there's no market for a life estate. Who would want to buy an undivided 50% interest in a piece of property in partnership with me? There's no real, in other words, if you think through all of your concepts of selling things, have you ever bought a 50% interest in a car or a 50%